viewers, welcome back to the show. Before the break, we're talking about this case of Ewer and the Transport Accident Commission. What was the final result of this case, Rob?
Ultimately, they decided that there wasn't the Valenti assumption of risk on the part of Mr. Baines. They did a contributory negligence calculation and they found that Mr. Baines was 10% contributorily negligent for getting in the car with Mr. Ewer.
Don, 10%.
Quite lucky on Mr. Baines, I think. There's a very low contributory negligence finding. I think in those circumstances it should probably a little bit higher.
Don, does their friendship and having prior knowledge of your friend's predisposition for alcohol play a part in determining the state of mind of a person?
Well, it does, because at the end of the day, having this culture and long-time friendship of this drinking, the law does say he should have known. He should have asked, he should have known that he was inebriated to the extent that he was, which caused the accident. And the accident happened when it looks like he just lost control.
So 10% you think is very light?
10% very light. And one issue that wasn't considered was seatbelts, which was quite interesting because both were flung out of the car. But nothing was taken off for the seatbelts. So ultimately, I think Mr. Baines, well, the insurance companies were fighting each other, but Mr. Baines was quite lucky to only get 10% off.
And Rob, if Mr. Ewer wasn't so intoxicated, do you think his level of contributory negligence would have been so much higher?
Look, it's hard telling the circumstances. The court really took into account the fact that Mr. Baines, they accepted, didn't know how drunk he was. And, had he had the chance to see how much he drunk, had he appeared more inebriated, I think that contributory negligence would have been a lot higher.
But the fact that Mr. Ewer was so inebriated himself, he couldn't possibly work out how bad Mr. Baines was. That's where I'm coming from.
Well, one of the witnesses, which is interesting, who was the last people to see Mr. Ewer and Mr. Baines before they left, he said that Mr. Baines looked very inebriated. He was in the car swaying, but in fact got out of the car to get a can that had cans in the back of the ute, and he was walking fine. So in the car he looked like he was falling asleep, and when he was walking around he said he wouldn't even tell he was drunk. And
managed to change a tyre at one point.
And managed to change a tyre.
That's extraordinary. Let's go on to another case of Hogan and Transport Accident Commission. Rob, do you want to give me the facts of this?
The facts of this are quite simple, but they're a little unusual. Mr. Hogan was very unfortunate in that he was riding a motorcycle on a rural property and had an accident and sadly became a C6 quadriplegic, so quadriplegic from the C6 vertebrae down. Now, he had a rehabilitation specialist who was helping him, who suggested it might help if he had a modified quad bike, which allowed him to operate it, and it would have been heavily modified so that with his disability he'd be able to use it. And she thought it would be a good rehabilitation expense because it would help him to get back to his old hobbies. It's like a motorcycle with 4 wheels. Okay. And they tried to apply to TAC for funding for this rehabilitation expense, and the TAC said, no, it's not a rehabilitation expense, we won't pay for it.
Don, the reason why the Transport Accident Commission didn't want to pay for the quad bike is because prior to him making the application for the quad bike, they'd already bought a Volkswagen transporter that had been converted for him.
And modified, yes, that's right. Well, just for the viewers, in Victoria, if you're injured in a transport accident, Tony, you're entitled to receive some benefits from the TAC. One of those benefits is medical and like expenses, or funding of medical and like expenses. So the Transport Accident Act does dictate what the TAC can pay. Now, the TAC can pay for modification to motor vehicles, but also can pay for rehabilitation expenses. And that was the issue in this case. Was a quad bike a motor vehicle? If so, because the TAC have already funded a motor vehicle, are they liable to fund another motor vehicle? Is it endless? Or if it's not a motor vehicle, what other provisions can the TAC fund?
Well, the ideology of the legislation is to try and get people back to as much normality as possible, notwithstanding they've got gruesome and horrific injuries. Is that correct, Rob?
That's exactly right. And under the circumstances in this case, they found that it wasn't a motor vehicle. It wasn't intended to be used on public roads, which is necessary under the Act. It had very loose suspension. It was high off the ground. There's potential for it to topple over if it wasn't used properly. So then it came down to whether it would be a rehabilitation expense, which the court ultimately accepted that it was.
So in the first instance, when it went to the Victorian Civil and Administrative Tribunal, he failed in getting his quad bike, didn't he, Don?
That's right. And
so then it was appealed to the Supreme Court?
Yeah. So the issue about the motor vehicle is that it has to be a vehicle that's used or intended to be used on a highway, public road. So the quad bikes are not registrable, but they have the headlights, they have everything attributable to a motor vehicle, but in this case, they say it's not intended to be used in a highway. And they use the example of Formula One. Formula One is everything, the headlights, brake lights and all those things, but you don't see them on the roads. So that was where it came down to. It was not a motor vehicle, so therefore they looked at different legislation. They looked at the actual sections that are allowed to maybe fund this quad bike, and one of those sections was about rehabilitation expenses.
Well, seeing they bought him his Volkswagen Transporter, would the quad bike be a luxury, Rob?
Well, I don't think that's really what they were getting at when they tried to get it for him. Not that it's something that would be just for a bit of fun. It was really to get him back on track, because when you're a quadriplegic, you're so limited in what you can do. And for him to be able to go back to one of his old hobbies would do enormous benefit for his physical and psychological well-being.
Well, how would he get any physical benefit out of it? Because he was a quadriplegic from the neck down.
Well, just the enjoyment of getting out there and doing something they did before, the air on your face. You can just imagine what he would enjoy in that sort of sport.
Tony, it doesn't have to be full restoration to their life before the accident. It can be a partial restoration, as long as it's some expense that is reasonable and it's for the person and gets them back to some sort of normality. Try to.
Do we know if the plaintiff had his whole level of reasoning? Could he think normally?
Well, I didn't go into that much detail, but
as far as we can tell, he did.
Yeah.
Okay, look, there's another interesting case in relation to rehabilitation. It's a matter of TAC and Kutz. Do you want to give me the facts of this one, Rob?
Yeah, in this case, Ms. Kutz was injured in a transport accident and had some spinal injuries, nothing debilitating to the extent that in the previous case, but enough that she wasn't able to do a lot of household things and gardening. So the TAC provided her with household services. So someone was coming over and doing a bit of cleaning a couple of times per fortnight, and also some gardening services. Now in this case, the TAC terminated her entitlement to this cleaning service after 5 years, saying that it was a home service.
Domestic service?
That domestic service, which is only payable for 5 years.
And what happened then, Doc?
Well, again, interpretation of legislation, there is a section under the Act that allows the TAC to fund what's called a disability service and fund what's called household help. So not home services, household help.
What's the prerequisite to getting that disability service done?
Well, disability, you've got to show you're disabled. Whereas home services...
You've got to have severe injury?
No, just show that you're disabled. So in Kutz's case, she had a back fracture, she had limitations, ongoing limitations. She wasn't a severe injury as defined by the law, which is quadriplegics, paraplegics and all that. She was just having these ongoing problems, which we see quite common in these type of matters, but she showed that she was disabled and therefore entitled to ongoing household help. So even though there's two different words used, home services, household help under the law that did end up saying, the courts end up saying that there's really no difference in it, but different entitlements show that, for example, disability service.
Don, we're playing with words. I mean,
we are.
The service continued after 5 years.
Service
under a different
continued.
section of the legislation.
That's right.
Viewers, we've come to the end of the show. Don, thanks for coming on board, and Robert.
Thank you, Tony.
And I want to thank the viewers for watching. Stay tuned for future episodes, and also please stay safe.